Hello and welcome to the Minimum Competence episode for Friday, July 24th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, a star Supreme Court lawyer is sentenced for tax crimes. The Justice Department backs down and drops its subpoenas of New York Times journalists, and the Paramount Warner Brothers merger stays frozen into August. Let's remember, the right to be heard would be, in many cases, of little avail if it did not comprehend the right to be heard by counsel. And read today's legal news. On this day in legal history, July 24th, 1937, the state of Alabama dropped all charges against 4 of the 9 young black men known to history as the Scottsboro Boys, a small, belated measure of relief in one of the most notorious miscarriages of justice in American legal history, and a case that helped reshape constitutional criminal procedure. The 9, ranging in age from approximately 13 to 20, had been arrested after riding a freight train through Alabama in 1931 and falsely accused of raping 2 white women. Within 2 weeks, in a series of rushed trials before all white juries, 8 of them had been convicted and sentenced to death. The trial of the youngest, Wright, ended in a mistrial when the jury could not agree on whether to impose death or life imprisonment. The extraordinary speed and unfairness of those proceedings produced 2 landmark Supreme Court decisions that still shape the rights of criminal defendants. In Powell v. Alabama in 1932, the court held that the defendants had been denied due process because they had not received the timely and meaningful assistance of counsel needed to prepare their defense. The court's holding was formally limited to capital cases involving indigent defendants incapable of adequately defending themselves, but it became a foundational step toward the broader right to appointed counsel later recognized in Gideon v. Wainwright. Then, in Norris v. Alabama in 1935, the court overturned Clarence Norris's conviction because Alabama had systematically excluded qualified black citizens from its jury rolls. Building on earlier equal protection precedents, the court made clear that a state could not accomplish through discriminatory administration what the Constitution prohibited from doing expressly. The Scottsboro cases dragged on for years through retrials, reconvictions, and despite one accuser's recantation, appeals, and slow partial releases. On July 24th, 1937, Alabama dropped all charges against Willie Robertson, Olin Montgomery, Eugene Williams, and Roy Wright. Prosecutors expressly concluded that Robertson and Montgomery were not guilty. Williams and Wright were released principally because of their youth and the 6 years they had already spent imprisoned. The 6 years they had already spent imprisoned. The state continued prosecuting or imprisoning the remaining defendants. The significance of the Scottsboro saga is twofold. It exposed nationally how the Jim Crow justice system operated against black defendants, and it forced the Supreme Court to give practical constitutional force to protections, that's meaningful representation by counsel and freedom from racially discriminatory jury selection, that we now just consider basic. It is a reminder that some of the most important rights in American law were secured through the suffering of people who were themselves never fully given any real measure of justice. Thomas Goldstein, one of the most prominent Supreme Court advocates of his generation and a co-founder of the widely read SCOTUS blog, is being sentenced today after a jury convicted him of tax evasion and mortgage fraud. Goldstein argued dozens of cases before the Supreme Court and built a celebrated appellate practice, but prosecutors showed the jury a hidden second life as an ultra high-stakes poker player in games running into the tens of millions of dollars. The jury found him guilty on 12 of 16 counts, including tax evasion, assisting in the preparation of false returns, willfully failing to pay taxes on time, and lying to mortgage lenders. The conduct is a case study in exactly the kind of sophisticated evasion I wrote about in Forbes this week. Prosecutors said Goldstein concealed millions in poker winnings and losses, diverted his law firm's legal fees into personal accounts to cover gambling debts, and directed people to pay his creditors so the money never showed up as his income. That's not a wage earner whose taxes are withheld automatically. It's precisely the complex, hard to trace arrangement that takes real investigative resources to unwind. The Justice Department has asked for 8 years in prison. The significance is a pointed reminder that the tax laws reach even the elite of the legal profession, and that when the government does devote the resources to untangle a sophisticated scheme, the accountability can be severe. A man who spent his career at the pinnacle of the legal system now faces the system's full weight. The Justice Department has dropped its subpoenas of New York Times journalists over their reporting on the Qatari-donated Air Force One, a striking retreat that came after a federal judge tore into nearly every aspect of the government's approach. We've been following this one. The subpoenas were issued July 10th, days after the Times published its stories, seeking grand jury testimony and phone records to unmask the reporters' sources. At Thursday's hearing, U.S. District Judge Aaron Subramanian pressed the government hard. He criticized prosecutors for hastily issuing subpoenas that the DOJ's own lawyers admitted were riddled with inadvertent errors, and he chided them for asking another judge to gag phone companies from telling the journalists their records had been subpoenaed, days after the department had already publicly confirmed the subpoenas existed. Faced with that skepticism, the government agreed to withdraw them. A Times lawyer called it a, quote, great day for the First Amendment and a great day for the rule of law. The significance is worth stating precisely. This wasn't a sweeping constitutional ruling establishing a reporter's privilege. The DOJ retreated before the judge had to decide the hard First Amendment question. But it's a concrete example of judicial scrutiny working as a check. When a court forced the government to justify subpoenas aimed at the press, the case collapsed under its own sloppiness and overreach. After a month of friction between the administration and the media, the press got a clear win. And finally, the pause on Paramount Skydance roughly $110 billion acquisition of Warner Brothers Discovery has been extended. A federal judge has now frozen the deal through August 17th. When we covered this earlier in the week, U.S. District Judge Araceli Martinez Alguin had issued a short 14-day restraining order at the request of a dozen state attorneys general. Now that freeze runs deeper into August, buying the court time to weigh the state's request to block the merger outright. The state's antitrust theory has sharpened. They argue the combination would lessen competition in three specific markets: wide-release theatrical film distribution, top-grossing theatrical distribution, and basic cable licensing, harming movie theaters, cable distributors, and ultimately, audiences. Remember the framework. Antitrust law lets courts halt mergers that would concentrate too much market power, and a pause like this preserves the status quo so the deal can't close before a judge decides whether it's lawful. The significance is that time is itself a weapon in merger fights. Every week a deal sits frozen adds cost, uncertainty, and the risk for the companies, and it gives regulators and challengers leverage. Here, it's state attorneys general, not federal antitrust enforcers, driving the challenge, and they've now kept one of the largest media mergers in history on ice for the better part of a month, with the decisive rulings still yet to come. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcast. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes, an email, newsletter, form. We'll see you back here on Monday. And until then, remember, no person in this country is so high that they are above the law.